Ladies and gentlemen, thank you for taking the time today to be with us and welcome to the in-house counsel forum program. My name is Kingshuk Banerjee. I'm a partner in Khaitan and Companies Disputes Practice Group. As many of you may be aware, the in-house counsel forum program is designed to provide training and education on legal matters and practice that is relevant to in-house counsel teams, as well as a discussion on contemporary issues which are again relevant to the in-house community in India. On this slide on your screen is the agenda for today's webinar. Um, in summary, we will have an expert panel discussion followed by a Q&A session with audience questions. We have already received several audience questions, and if you do have more questions in the course of the webinar, please submit them using the facility provided in the webinar portal. If we can't cover all questions in the course of the webinar, we will respond offline by email after the webinar. We will also share with you after the webinar summary notes of today's discussion and a recording of this webinar. We will do this after the webinar. As you are aware, the topic for today's discussion is how to manage litigation better. Managing disputes is a fundamental element of the role of any in-house counsel in every organization, and when the dispute escalates into a litigation in a court or an arbitration, the management role becomes even more critical because it is not just financial issues that you're dealing with, you're potentially dealing with reputational issues and various other factors. In this session, we will explore how in-house counsel manage litigations within their business frameworks. The panel will share their experiences in managing both small as well as large matters and the strategies, tools, or levers they use to manage litigations. And in so doing, we hope to provide some insights for the audience and perhaps some assistance based on the extensive experience of our panel today. Everyone who has registered for this webinar should have received by email already a summary of the panel members and their credentials to talk on today's topic. So I won't spend much time introducing them. Suffice to say, they are all experts in this subject matter and qualified to express views on these issues. On our panel today, we have Vivek Mittal, who's the Group General Counsel at Dr. Reddy's, Natasha Mangat, who's the Senior Legal Counsel, Disputes and Government Investigations at Standard Chartered Bank, and of course, last but not the least, Ajay Bhargav, who's a Senior Leader at our Disputes practice. With those introductory comments out of the way, I think let's kickstart the discussion right away. And Vivek, may I put the first question to you, which is that how important is it to align your litigation strategy with your organization's broader business goals and objectives, and what place does a corporate litigation policy have in this context?
So, Kingshuk and Ajay, thank you for inviting me here. Happy to be always part of any Khitanko webinar. It's always contentful. There's a lot of content throughout the sessions, and I really love it. So, thank you. Pleasure to be here again. Not all companies, Kingshuk, will have litigation policy. We do have in some shape and form, not so developed. But the question which you ask is whether litigation has to be strategically aligned to companies' goals or not, or companies' vision or not, or companies' business or not. I think answer is yes, especially for us. We do litigation in two pieces, right? One is purely IP litigation, we being pharma company, and other litigation is general litigation. Even in general litigation, there are many strategic elements, and I'll just lay it out for this group and for the audience. So IP litigation is very important for us because let's assume in US, we do challenge and we do file a lot of para 4 litigations, and those are to challenge the existing patent of the innovator company. The idea is that we challenge their patent and we get some kind of exclusivity in relation to the drugs. That's the core strategy of our business, of any generic pharmaceutical company. So that's a classic example where litigation is directly linked to firm strategy. I can give number of examples like that. We have few blockbuster products. We have many products where we had exclusivity in past and will have exclusivity in future. And we do design them much in advance. Uh, you won't imagine that design even happens 10 years in advance. We do plan that we will be launching this product 10 years later, and we will have to challenge this patent. That design happens in our kind of company or any generic pharmaceutical company maybe 5 years or 10 years earlier. So it's strategically aligned, and we do see that what is the patent cliff, when patent cliff is expiring, which drugs to target for, what will be the pricing after the patent goes away, what will be the pricing during the exclusivity period when patent is existing and we get exclusivity. It's a clear cut strategy. So that's one classic example where litigation is directly linked to firm strategy. Other classic examples I can pick up in India, and Ajay, helped us in past and will help us in future as well, is in relation to NPPL litigations, where government comes out with the pharmaceutical drug prices, and we actually litigate that those drug prices are not directly fixed as per the policy or as per or as per DPCO, or the process was not followed. That's directly linked to our bottom line. Just take an example that we have a drug, the market of that drug is, let's say, 100 crores. Now tomorrow, government comes out and says that price of that drug will be reduced by 10%, so our bottom line straight away is slashed by 10%. Now we have to strategize it well, that we do that litigation so that we challenge government fixed price fixing if it is actually challengeable or not. And I think that ascertainment we do, whether proper process was followed, whether price fixing in relation to that drug should happen. And if we do, then we challenge first before NPPA. There also, that's also dispute resolution in one sense, and then probably in high court by way of rate. Again, that's classic example by which litigation is directly linked to firm strategy. Then there are many ancillary litigations, right? Either we go after brands. We are a branded generics company. We have identified at least 50 brands which we have to protect. We have identified 20 brands where we'll go after anyone globally. That's directly linked to our strategy, because if somebody challenges those brands, or somebody come near to those brands, then it directly affects our top line and bottom line. Fourth example, and I can continue giving example, but I'll pause after fourth example, is counterfeiting. That's one example where we do litigate a lot. We file FIRs, we actually do raids, we actually represent before government authorities, etc., etc. Though not directly litigation, but that creates a lot of litigation for us. So if anybody is producing counterfeit drugs, we actually do raids. We then start filing any kind of suit against them. We file FIR, etc., etc. But that counterfeiting, if we don't stop, that directly affects our top line and bottom line again, and that's directly linked to our firm strategy. So these are the four examples. But if you want, I can continue giving, but I'll take a pause, hand it over back to you.
No, thank you, Vivek. I think you've answered the question clearly, that there's no one fit all solution. It's important that you think about litigation from a business perspective, from your business perspective. I think that's clear. Natasha, next one is for you. Again, a common question: how do you evaluate and make critical decisions around whether you want to litigate, whether you don't want to litigate, whether you want to settle, pursue negotiation, mediation, or some other strategy? I know it's not always a choice. Litigation is not always a choice, but when you do have the choice, how do you approach it? I think that's the question.
Oh, thank you, Kingshuk. And I think the question itself is a good segue from what Vivek was talking about. That one is to say that there's a litigation policy, but I think most companies, at least in the financial industry as well, and I imagine in other industries as well, would have a litigation guidance, perhaps. There can't be a policy that you have to follow. Everything has to be a little different, like Vivek said rightly. And even in the most critical decisions on the approach towards a dispute resolution, which could be litigation or mediation or arbitration, all of that would also depend on various factors which are very business relevant. As soon as there is a beginning of or indication of a dispute arising between parties, one very simple way of dividing them is that we disputes that we would start litigation. And in the financial industry, these are quite already well developed strategies. We have SARFACI, we can have resolution through IPC. Those are a few which are already set in stone, and that's how we go about it. But before going there, and we think that there are indications where our risk teams can bring about indications of maybe stress in the industry. Those would be the calls that we would take on whether you want to first resolve and also manage the relationship if you are instigating that dispute. And if a dispute is coming towards you, then also we'd always first be speaking to, it would be a client or a customer most likely than anyone else, on whether there is an ability to resolve it. The principle will always remain what is the quickest, most efficient, time-wise and cost-wise way to resolve the dispute. Sometimes, like you rightly said, there is no option but to litigate. But the litigation part would always be the last option. Nobody wants to be in courts for a very long time, especially in India, right? It can take years, sometimes 25 to 30 years to really come to a final conclusion. So nobody wants to be there. Nobody wants to litigate. But like you rightly said, sometimes we don't have a choice. But before making that choice, like you said, that critical decisions that we take into considerations three big aspects, and of course there'll be further divisions. One is really how strong or strength in your claim or your defenses. Getting on top of that very quickly. Sometimes you have all the facts in place, so it's really easy to get there. But a lot of the times, most of the times, facts would come clearly, and 100% of them only over a period of time. So with 50% or 75% perhaps of the facts in nature, you still need to first quickly evaluate the strength of your defenses and your claims. Second would be the resources that you are willing to or able to or want to. Really, all three apply. Resources means monetary resources, financial, human resources, external counsels like you to help us to put them together, depending on exactly what is the impact of the litigation. Do we really need to be in this dispute? Can we finish it off as early as possible and amicably? That's why negotiation would always happen. I don't think there's anything else other than negotiation first happening. There are some disputes in which it doesn't, but in most cases, you do have that ability to negotiate. With mediation, which would be the maybe logical next step, but often isn't. In my experience till now, um, we have not, by we, I also mean like the financial industry, I don't think it has taken so well to mediation till now, because most of the facts are pretty clear and mostly it's civil in nature and some can be criminal, but then mediation doesn't come in picture. But something like a commercial suit, where there is pre-institution mediation, so it's kind of court mandated. I have seen that it often comes down to what has already happened in negotiation. How much are you planning to put in? How much are you willing to negotiate? And it can come to a close pretty quickly, it going to litigation more or less. Unless, and the settlement aspect of it is always open. It's open before, it's open while deciding whether there'd be a litigation, and it's open even when you are in litigation most of the times. So that settlement aspect of it is something that always hovers over all decisions. As far as the aim being, like I said, what is the most quickest, cost efficient, and time efficient way for the best possible outcome for both parties, more often than not, than just one party. I'll stop for a minute if you want to have some more questions. I see Vivek's hand up.
Yeah, I can see Vivek's hand. Vivek, please go ahead.
Yeah, so I think before we go to Ajay and Ajay, I'm sorry I'm keeping you waiting, but idea which always comes to my mind is that I always put litigation in two buckets, right? One is proactive litigation, one is reactive litigation. Proactive litigation is which is completely aligned to company strategies. To my earlier point, the way I gave examples, litigation has doesn't have to be completely reactive. Reactive is that you get into an agreement dispute with someone and then you start thinking that how to mediate, how to reach to a conclusion, how to sort of whether to go into mediation, arbitration, file a suit. That's purely reactive. But I have seen many companies and we also do, as I said, patent litigation is purely proactive. It's that we take it upon ourselves that we need to litigate. And there are many companies like that in India and globally, which I have seen. That proactive litigation is one thing which is directly linked to company strategy. So again, just a food for thought: proactive and reactive litigation. I'll pause here.
That's really very helpful. And both of you alluded to mediation, arbitration, and other alternate dispute resolution mechanisms. And this might seem like an obvious question, but in recent times there is a growing debate on the benefits of arbitration, and especially we've seen some developments in the arbitration space, and one wonders whether arbitration is a preferred mode of resolving commercial disputes today. And maybe Vivek and Ajay, you can follow if you have any thoughts on what you feel about arbitration versus litigation as means to resolve disputes.
So, whatever I'm saying, my thoughts are my personal thoughts, and I
Of
don't want
course,
to bring it the way company does it. But what I want to tell you is that there was a time when I used to provide arbitration clauses in every agreement. Then there was a time when I didn't provide arbitration clause in any agreement. Now there is a time I'm calibrating which in which agreement I should provide arbitration clause uh, versus in which agreement I should not. So I don't think that it's a mindless thought that you just go ahead and provide arbitration clause. I think there was a time when people used to do it, that, oh, don't worry, let's put arbitration and let's see how it goes. I think now more and more I'm seeing GCs, they are actually taking this calibrated approach of, oh, this agreement is very important. If this has to go into dispute, then what should be the way of resolving the dispute? Do we go to arbitration? Do we actually litigate? Do we actually go to court? Uh, I think it's getting very, very common these days to think about it. If you talk to me about purely India, let's say, if I have to strategize, then probably only for Indian disputes, I will be more tilted towards Indian courts versus arbitration. However, if it is cross-border, then probably arbitration could work better, because for cross-border there are multiple parties involved, or there are parties involved which are into different countries, and then you have to think through that how do you litigate, which court you go to, whether that court's award will be enforceable or not, and then you try and understand whether arbitration is better or not. I'm more and more seeing mediation, Kinshuk, where people are saying, you know, med are med. I think I'm seeing this term more and more now, which is possible. Which actually I did it very recently in one of the case. Not so successful, but I just want to tell you that people are more open to it now. But for arbitration, I have one more thought is that in India, arbitration has become very, very, very expensive, right? The way initially it evolved is that expert in that area will be the arbitrator. I'm not saying what I'm gonna say is not it's not right or wrong, but I'm saying that more and more we are saying that high court judges, Supreme Court judges are actually getting into arbitration. I'm not saying it's bad. All I'm saying is that that's leading to the same process as we were in earlier, but in a different format through a ad hoc or institutional arbitration. We go through the same process, probably in little lesser time, but more expensive, right? So again, to my point, what we are trying to say is that if we have to get into any dispute with any party, I would rather calibrate much in advance. That if you have to arbitrate, then probably how much money I'm gonna end up spending, and versus whether going to court is a better option for me versus going for arbitration. And probably what I would do is I will say mediation and then going to court. I'll take a pause.
got it. But I think what very clearly emerges, Vivek, from your response is that uh, enough time needs to be put when drafting your contract, because one one issue that always arises is the arbitration or dispute resolution clause is paid no attention to when you're drafting the contract, because nobody thinks about a dispute when you're drawing up your contract. But what you're saying is that it's important to think about that clause when you're drafting the contract, because if you don't, then the chances of litigation and getting embroiled in unnecessary, needless litigation goes up. And just saying that, Ajay, anything to add to that? And generally, your thoughts on dispute resolution clauses. What are the considerations? What you should think about? What you may not think about? Anything on this topic?
Thank you so much. And it's so heartening to hear Natasha, Vivek on this from an in-house counsel perspective. So Vivek has already taken words right off my out of my mouth and my heart. So see, when you talk about litigation versus arbitration, so I always say I'm an arbitration baby or arbitration child because I graduated in 96, and that's when the revamped Arbitration Act of 96 came about. So we all say the heart was in the right place. That was the whole idea. Lessen the burden of the courts. Too many civil cases were going in the higher courts. Pecuniary value of the higher courts was available to, say, Delhi. So I'm from here, so I can share experiences. So that was the right intent. But yes, along the way, what's happened? We added another layer. Earlier, you had a suit, appeal, Supreme Court. With arbitration, you got arbitration, objection, appeal, Supreme Court. So we got ourselves into a loop where a suit would take probably 8 to 10 years, but so did arbitration. So it lost it's the whole incentive kind of behind it. But then with the amendments we got in timelines and all, again, the heart is in the right place. But obviously, to plug the gaps, now we are again going into the committee route, observation, stakeholders, sharing their experiences. Because at the end of the day, while we all talk about litigation versus arbitration, one thing is how do you actually monetize the decree or the award? Ultimately, that is the main challenge in which we have seen in India. We all talk about arbitration, and frankly speaking, the first time I heard this term, which was called paper award, so I was really dazzled by this term given by a very eminent senior counsel, and I was a very young lawyer. I thought paper award is on paper, stamp paper. What does he mean? The whole idea was you had an award which you can't enforce, because by the time you ended up with the arbitration, the losing party didn't have anything to give you. So that is on the arbitration piece versus litigation. But of course, Vivek also spoke about a very, very interesting things, that if as a general counsel and being Vivek Mittal, if he's thinking between suit and arbitration clauses, then Kingshuk, you and me need to work harder in life as lawyers, external counsel. And so when you talk about what is your key consideration, see, again, we have all along, we as lawyers only share experiences. I always believed if you are going to be a claimant in a contract, then okay, prior to that, one must be clear what your commercial contract may lead to eventually, what kind of dispute. If you are going to be a claimant, the thought was better have arbitration, easier to manage, depending where you are in India. Because see, we all talk about Delhi, Mumbai, but if you see, that's not India. India is huge. Every state has its nuances when it goes to court. So hence, before you drafted the clause, we thought, all right, if you are going to be a claimant, get in an arbitration clause so that things will be expedited. If you are going to be at the receiving end, be happy with the civil court, which will take 5 years, 10 years, who knows. So that was the thought. But then before you start getting into a clause, I think there should be clarity of dispute, what it's going to be. If you choose arbitration, better make sure it confines to the language of the act, that it should be in writing, meeting statutory needs and whatever the things requirements are. The age old debate, seat and venue, should be clarified, because we are still living with cases 20 years old where the place is Paris and the challenges are in India. Indian High Court says something, Supreme Court might say the other. So these are some of the issues which you definitely must keep into account. If you choose arbitration, nowadays there's a lot of talk about ad hoc versus institutional. I don't want to get there because we have fantastic institutions, but I still believe in our hearts we are a very ad hoc arbitration based country. We love to make sure that our nominee is on the tribunal, because we must change that mindset that my man on the tribunal is my man for the award eventually. That doesn't happen. So again, you should be clear about, if you are choosing arbitration, have a clear arbitrator appointment procedure. Another thing on this, I feel very unfortunately, appointment of arbitrators pan India are not the same. They are still going beyond the period which our apex court has said, please appoint arbitrators in the time bound manner. That's not happening. So the clauses have to make it clear. You choose one, you choose three, but make it clear. Then your applicable laws again. So I think the best part of a dispute clause is first you check which side of the fence you are going to be, then prepare it. And frankly, we all have seen some fanciful agreements. First, there's a mediation between the CEO to CEO. Then you have somebody else coming in. Then you have committees coming in. So there has to be clarity of your clause that if you want to go on with first trying to resolve internally, please do so, but have a proper mechanism for doing that. So I think we have all seen these fancy clauses like that. So with that, over to Vivek with his experiences.
So, so it's a funny thing that what I've learned from my experience is that in arbitration for corporates, uh, you know, arbitration cost is a big thing. So I'll give you my example. So back in about 12, 13 years back, in one of the contracts, normally provide three arbitrators, normally provide that arbitration will be in Delhi. I'm just giving an example. Arbitration was somewhere else. What we realized is that cost of arbitrators and going to Delhi, taking a lot of people to Delhi, taking witnesses to Delhi became a lot of cost, right? And we realized that the amount of dispute was much lesser versus the cost which we are incurring towards arbitration. So nowadays, what we have started doing is we have started anticipating that what could be the cost of arbitration. And I'm saying as a corporate, we must actually see in advance that if you are providing three arbitrators and then you are saying that each arbitrator should be no less than high court judge, then what kind of cost you are trying to incur. If you are taking high court judges, then you have to hire good law firms, right? You cannot run it on ad hoc basis, you cannot run it on your own. Then the cost of law firm, then probably your own resources, probably their stay. I'm just giving you multiple examples. You'll have to conduct arbitration in a hotel, a conference room, small things,
Yeah, yeah.
small things. Lunch, dinners, right? These are small things, but when you add up over the period of time, maybe arbitration running for 2 years, it adds up. So as a GC, I would always think that if I go to arbitration, in relation to any dispute, what will be my cost, and accordingly nowadays I've started taking care that if it is an important matter, I clarify well in advance that single arbitrator cost of wherever we fly should be borne equally by parties, etc., 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 etc. Because ultimately, whatever way you slice and dice, all arbitration are commercial disputes, right? We are right now not discussing arbitrations of IPRs, and we are not discussing arbitration of criminal cases. So whatever way you slice and dice, they are commercial. So they need to drive a commercial value, and I think Shrevels also wrote that cost benefit analysis in the chat, and I completely agree with that, because unless you are able to prove that arbitration will bring more value to you versus its expenditure, then there's no point going to arbitration.
So if I can just add one live experience, sorry, Kingshok, we
Yeah,
have
of
a
course.
lender contract, pure lender borrower contract. Money lent is 220 CR. It doesn't have an arbitration clause, and the territorial jurisdiction is Delhi, so the court fee is 2.2 crores. Had they put in a sole arbitrator, it would have a capping of 37.5 crores. Lakhs, sorry for the crores and lakhs. But so sometimes you're absolutely bang on point. Before you get into a contract, I was surprised. Why wouldn't a 200 crore lending have an arbitration clause? Knowing where you'll end up in the court fee angle. Plus, again, senior counsel, I agree with you, barring the lunches and dinners which we don't get in High Court, to that extent, High Court canteen is very reasonable.
Oh, this is I think very very useful, and often Vivek, as lawyers, we view arbitration very differently, right? So it's good to have these insights. In fact, we did a survey where we had some responses which were very surprising, but at the same time, that's food for thought, because ultimately you're the user of this mode of dispute resolution mechanism. If you're not happy with the way disputes are getting resolved, then it certainly needs to be addressed. So lot of food for thought for us and
So
arbitration
Kinshuk, sorry,
practitioners.
one more comment is, I will then take you 30,000 feet, right? Now we are discussing as lawyers, but for corporates, arbitration is a service in one sense, right?
Correct.
If you zoom out, it's a
Yes.
service which is provided by law firms and probably arbitrators. Does that service give you a better value versus what value you want to receive versus the expenditure? I think that's the question we should be answering. And if that service
Absolutely.
doesn't bring you the value, then we are doing something differently, right? So I'll pause.
Oh, absolutely. I think that's lot to think about for us. But just staying on value, and again, this was one of the audience questions that we had, and we thought it's worth asking. Is generally, and this is not arbitration versus litigation specific, but generally, uh, do you do you would your approach differ if it's a high value dispute as against a low value dispute, or would you have a consistent approach irrespective of the quantum or value? And um, Natasha, you want to maybe respond to that? You've been quiet on the
Sure,
arbitration
sure.
discussion.
I was patiently listening to both Vivek and Ajay Kingshan. It's very interesting conversation. I just think that if I could, before I go to your question, if I could add 2 points on the whole arbitration versus litigation debate, which will stay for a very long time. One one was that I've also seen now contracts which have both litigation and arbitration clauses. Now there are certain jurisdictions in the world, not in India right now, where they allow it. In India, and there are certain jurisdictions which don't allow it. So if you have a litigation clause and arbitration clause, because it causes the confusion, the validity of the clause is often questioned in the courts, especially in India. But I'm still seeing clauses in contracts being negotiated having both. And I'm trying to always tell them that if you want both, be clear as to which dispute goes into litigation and which dispute goes into arbitration. The second point I wanted to make was also about, other than costs and time between litigation and arbitration, which will go up and down every now and then, depending on who's saying it. I think one thing that arbitration wins in, and is a big point, is confidentiality. When there is a dispute going on in arbitration between two parties, and the dispute can be on very confidential material, then right before drafting we would consider that, because once you're in courts and you're in litigation, everybody's up to hear whatever's going on, including have some reference to what is being put in evidence, whereas arbitration provides that cloak of confidentiality if that's what's important for the underlying dispute. So I just wanted to add those 2 points because, uh, and just one on Ajay, the example you gave on a lender and a borrower. I think the distinction comes about when the lending is secured and if it's not unsecured. When the lending is secure, there are often disputes which are not arbitrable. So even if you have a clause, it will fall invalid. So you don't have them. And if you have security, there's also this whole name and shame theory, right? Like the Dirty Dozen, which came out before IBC did. Uh, which you don't get in arbitration because of the cloak of confidentiality. So that is perhaps one of the consideration, at least in the financial industries, not looking at arbitration clauses when it's a secured lending or it's a big lending. I don't think very big lendings would be unsecured, but there are a few which remain. So I just wanted to add that, and that brings me to the question, Kingshuk, as well, that whether approach should be different for high or low value. In principle, I do not think that approach should be different. Litigation or a dispute is a dispute. Each one is very important. But in practice, of course, if it's a very high value dispute, then the impact and the risks associated with it also become very high value. Now, of course, there are a lot of frivolous ones. They could be as high value. I've seen, people asking for millions of, tens of millions of dollars for saying that, because of this entire dispute, I have had this much stress and trauma, which of course that can be reasonable, but I don't think that would be looked at as reasonable by any of the courts. So that makes the dispute quite high value. But I think in the beginning itself, if you have an analysis and very rightly said, like a cost benefit analysis of a high value dispute and also low value disputes. That's how you would allocate resources to it and approach to it in time. And by resources, I also mean time. You don't want to spend hours and hours of time of a lot of senior counsels, senior lawyers, and a large number of in-house resources as well on a very small value dispute. But you would do that for a big value dispute because the impact could be that much. Unless you discover that it's a frivolous dispute and we don't need to get into it and we can organize it better. So right in the beginning, we could do that. That's one approach. The second approach, I would also think for small value disputes, they don't lose value because they're often in masses. There are so many of these disputes that they will, and I think Vivek rightly pointed out to that in an earlier discussion we had also, that small value disputes have so much value when they are massive in number, and they obviously throw out a pattern, which can be a very good way of giving back to business, to point out exactly maybe here is where there are loopholes, or maybe here is where we might not have looked at the larger pattern that is emerging to fix those processes and policies and be of better service to our clients as well. Because at the end of the day, whether it's a large matter or a small matter, we don't want to be in courts for a very long time. That could be arbitration as well, like you were talking.
Helpful. Vivek, any thoughts you want to add to that?
So the people obviously will care more for a large commercial dispute or large issue versus smaller. Just to give an example, for corporates, uh, either very large commercial value or a criminal matter takes sometimes a lot of center stage, especially criminal matters against either KMPs or directors take a lot of center stage, and people are willing to spend whatever money because of the sensitivity involved. However, there are smaller issues as well, which, if not taken care well in advance, then they can impact a lot of your businesses. Again, I think I was giving example of, let's say, labor dispute. If you have a certain kind of labor or blue collar within your manufacturing setup, whether they are workmen or not, that is a very small dispute, and it starts with probably one small lawsuit, one small hearing before labor inspector. But it can turn into a bigger battle later if you don't take care it well. It also hurts back the companies, right? Because if you don't take care it well, then probably people, though they are not workmen, but can be considered as workmen, and they have different rights and obligations in relation to company. So again, it depends. Not all smaller disputes take center stage, but there are smaller disputes which, if you see cumulatively or their impact later, may have a very heavy impact. Then you have to take care of them like a large commercial dispute or a criminal matter. So again, it varies from dispute to dispute, and it's not necessary that you can make a general statement that, oh, it's a small dispute and I don't want to take care of it. So that's where I am.
Understood. Understood. Just moving on to a topic which I think is very important for a business in general, and I won't say in-house counsel, but as a business in general, which is the cost of litigation. Right now, again, how do you manage cost of litigation is a common question that is asked, because litigation is unpredictable, it tends to escalate. So is there some way that you think about approaching cost of litigation? Are there any tools, levers available that you can believe can manage costs? Maybe some insights on that, Vivek and Natasha.
Natasha, why don't you go first?
Absolutely, why not? I think that there are three ways, and this is where the collaboration between our law firms and councils and in-house team comes together. It definitely costs, sometimes very high cost, sometimes very low cost, and depending on how much impact that particular dispute is going to have, you allocate funds. But how much ever you allocate, you want to resolve the dispute as quickly with the lowest cost, right? And certain tools that I found helpful, I'd say, is one is to immediately be able to have this cost benefit analysis of impact, and that you take in best case scenario, maybe midway, because there can be some losses and some gains, and also worst case scenario. So putting all of that together, you can come to a specific cost that you might be able to agree to. Second is now to reduce that. Once you have that number, to reduce that, we work, and it's best to do that, to work with our counsel to see how much time, energy, and effort from both sides is going to be put into making the pleadings, for example, or getting it together for an opinion, for example. And to cut costs, we do then agree on various structures of fee courts. For example, is it going to be a kind of litigation which would benefit best by having hourly rates negotiated? There would also be capped rates for certain litigation, saying that, hey, this is going to take this many hours, so this is a cap that we can agree on to not cross, to have the budget in place over a period of time. There's also a mix of the two that we have often come together to say that, okay, we see these many hours, but we can't reach these hours. So at minimum, you charge us hourly, but capping it at a particular for a time period, say a year, or to particular stages of each litigation. So that would be with counsels and us. And the third is, and that this is more recent development because of all the technology that's now available to us, is also using more and more electronic platforms to be able to do our work. And this is more to do with discovery. There's one relativity, if I can say that as an example. I don't know how often it's being used by councils in country, but I think more and more so councils are also taking up relativity to do all the discovery and document research. It keeps everything in one place. It's quicker, and lesser number of people can spend lesser number of hours to really go through the entire discovery process. So using these new modes of and platforms of discovery and research, that can also help cut costs quite a lot, I think. More points to add, of course, I'm sure. Vivek, over to you.
Yeah, no, thank you. Thanks, Natasha. You covered a lot of ground, actually, certainly. See, I think litigation cost is one factor which comes as a first or second discussion whenever we enter into any litigation. Because ultimately, we have to see whether that litigation is giving us the cost which we are going to incur. And once we agree that, okay, let's go ahead with the litigation, then comes that how can you actually do it more rationally in a limited cost? How can you manage cost better? And there are multiple ways and means, and I can talk and talk and talk what all we do globally, but few methods which Natasha said that you cap the fee depending upon time, and I fully appreciate. There was a time when I used to always say that I don't care how much time you spend, but that will be the cost. But more and more I'm getting matured. I realize that that's not the right way to treat our friends like Ajay and Kinshuk, right? Because they are also spending their time, and they are also spending their effort. So why not we link it to the time period, and we say that, okay, if litigation goes for 1 year, then this will be the cap. So what we do is we start with the basic number first. So we say that, okay, what's your hourly fee? What kind of discount you're giving us on hourly fee? That's where it starts. Then it goes to cap, certainly. Then it goes to that if we cross this particular commercial, what additional discount you're giving us. So just to give an example, if we say, oh, if cost of litigation is 1 million or more, as soon as it crosses 1 million, 1 million, you'll offer us 5% more discount. If it crosses 3 million, then you'll offer us 15% more discount, and so on and so forth. And we do define that actually. Other way, and we keep on analyzing that what sort of work law firm is doing versus what we can do outside, right? And that also we do in multiple litigations. Just to give an example, document hosting. There are law firms who would say that, okay, we will do a document hosting for you, but document hosting with a law firm is far more expensive versus done with the probably professionals in this. In few litigations, what we have done is that it's an interesting theory that wherever there is a commonwealth dispute, we normally try and do analysis in India by a litigation lawyer who understands common law so that we can save cost of that jurisdiction. Just to give an example, if it is a litigation within Bangladesh, Sri Lanka, UK, or other Commonwealth countries, then what we do is we will hire an Indian lawyer and we'll say, oh, this is the entire dispute, these are the documents, and that could be plethora of documents, right? We will hire that lawyer and we'll say, why don't you do your analysis, prepare a report and send it to us. We will then take that report and take it to probably UK lawyer or Bangladesh lawyer or Sri Lanka lawyer or so on and so forth. And we say that this is what we have done. Do you see it differently or not? So that's one way to save litigation costs. And it depends upon litigation to litigation, but normally the easiest is that you establish a good relation with the law firm, negotiate on the fee the way Natasha said, more and more, based on discounts, based on, your volume, and then try and think how you can do it better. But again, I'll come to my earlier point. When you're drafting arbitration clause, very important for you to envisage that cost and actually address that in advance rather than dealing it later, because dealing it later is not possible at all. For corporates, it's a commercial dispute. It should derive you a commercial value. If it doesn't, then it doesn't make sense at all. I'll take a pause, Kinshuk.
But on cost, if I can add, for me, Vivek as a GC was never a general counsel, but a very generous counsel.
Ajay, you're costing me my job here.
He was he no no, but I'm saying in a good way. No, it's a good thing to hear all this. See, over the years, we have all seen so many different variants and models of fee structuring that it's an eye opener for all of us. And each time we get a new mandate, even from an existing client, we learn something new from the new teams, what they are seeing in the market. And actually, on cost, it's a lot to do with market oriented, market driven but for senior counsel. But we all know in India, there are also certain states where senior counsels are also engaged on a one time fee for as many appearances. There are appearances of senior counsel that in this fee, three will be covered and then more. We have states like Delhi, Mumbai, sorry, Maharashtra, where senior counsel per appearance. Over the years, everything has moved. But I would actually, I appreciate the candid views from both of you, which again, Kingshuk and me will go back and think through.
Yeah,
No,
Ajay,
I think
sorry, Kinshuk.
I can only say, sorry.
We have not talked about other ways, and maybe if you want, Kinshuk, we can talk about it. Is one is litigation funding. I think we are going to talk about it later during this webinar. Other way is insuring, insurance, and we have talked about it, and we have been exploring that whether we can do some kind of insurance, right? So just to give an example, in US we have product liability insurance. In product liability insurance, of course, we do cover litigation cost if it is personal injury in relation to a product or a drug. So those are other ways by which you can think of managing litigation costs. So what we can do is we can put litigation. So first of all, India, it's very difficult to get an insurance, but there are jurisdictions where you can do litigation funding, you can do success fee, you can do fee sharing models. Many times we do it, many times we don't. But I'm saying that those are also avenues available
Hmm.
outside India, which one can think of if you're going outside India, especially in US where litigation funding is very common, or sharing of profit is fairly common.
So since you brought up litigation funding, Vivek, maybe AB you can spend a couple of minutes just talking about what is
Yeah,
litigation funding. Do you think
absolutely.
it's at
It
all
is.
something that you think about?
Yeah, absolutely. It's very interesting. But just to allude to what Vivek just said, see, in India, lawyering always started as a noble profession. It was never a business. It still isn't. But on that, that's why the fee of senior counsel, and we all know the history of the gown. I hope you guys know how the flap was there as a pocket, senior used to appear,
Yeah.
whatever the client could pay would put in that little pocket. So the senior counsel does not discriminate between clients. But of course, along the way, now we have changed. But on litigation getting funded, I always have a theory. It's not controversial, but I'll share. It's always been there. In property matters, we have seen the ultimate buyer is funding litigation in by whatever means. Now, of course, litigation funding has now got a name, a face attached to it. So I think it's, of course, I mean, we have some data that the global, I mean, I've got these fancy numbers, $43 billion market by 2033. And the way it is happening, it's evolving. In India, it is not, it is being done and it can be done. But the way I see it is that the way the Indian legal landscape is, I'll be surprised if the funders really are able to have that risk appetite. See, arbitration is a different sphere altogether. There you have visibility, clarity of, say, timings. At least now we have much more than where we were prior to the amendments. You can still fund it. But to fund a court litigation in, say, I don't know, in states where your suit may be lying around for 10 years, I don't know. So maybe it's an interesting one for us to hear from our in-house counsel what they feel, because they will be the more users. But our field also comes in the interplay. I was approached by a lot of these companies in the past few years, and they say that when we want to fund, we will go to lawyers for evaluation of cases. So that is why you will definitely be a part of our ecosystem. But the question is, as a lawyer, we all know, we have all grown up in the same era and vintage where we say your case is arguable, maybe, could be, possibly you'll win. So how do you fund? So I may not be the best guy to answer this question, Kingshore, but I would rather hear from Natasha and Vivek.
Yeah, so
Natasha,
I
first
mine
you or Vivek?
yeah, go ahead, Natasha. Why not?
Thanks. Well, mine is a short one, in the sense that I have been hearing about litigation funding for years now in India. In fact, funders have come to country and have had conferences and discussing, but I personally haven't come across, not in India at least, an actual project in which there has been litigation and litigation funding involved. I have had one experience, but it was outside the country for litigation funding in the UK. And that also was questioned in the India leg by the courts so much. No orders passed as such that it's okay or it's not okay, but challenged, of course, by the opposite party a billion times, even though it's not in country. So for me, I think in India, at least litigation funding still has a long way to go because, like Ajay, you rightly said, every time I've spoken to a litigation funding house and asked them how do they evolve, they themselves are just not comfortable in funding litigation in India. It's because of the time periods that it could take and the uncertainty of the outcome, which will never be clear. Never be clear. I mean, yeah, there's always, it is arguable. You have 50-50 chance. It depends on the mood of the court or depends on the day that's going on court. So, no, I think in India, at least it's a long way to go till at least there are some case laws that come about clarifying exactly what the court stance is. I haven't really seen somewhere where it's absolutely clarified.
And also, I'm so sorry to intervene, but to add, last year there was this news item, if I'm not mistaken, Supreme Court admonished a lawyer for giving a chance of success to a client. And
Yeah, it's not
that
allowed.
was an eye opener where, again, this was a topic of conversation with these funding companies. I said, if you ask me and you want in percentage terms, I can give you random 80-20. Who's to check? If you win, it's 80. If you lose, I told you 20. So that was the Supreme Court's observation on lawyers giving chances like that, chances of winning a case.
Just to
So,
add to
so
that, Ajay, that is for external counsels and advocates, right? Against the Advocates Act and practice. In-house, that has to be done one way or the other. You have to be able to tell your
Yeah.
business that we definitely will win this. Oh, there could be some circumstances, but we
Yeah.
definitely, or you know what, this
Uh,
one is not going to go our way. Precedents say otherwise. So we have to be quite clear to business. So I think that way also an in-house counsel has to manage that framework where we give clarity to the business depending on the 50-50 that has been given to us by external counsels. You
so
were saying
for
something, Vivek.
Yeah, yeah. So I was saying that I completely agree. Litigation funding in India has a long way to go, Abhi. I don't think that right now we are in a stage, even in terms of our legal framework, that litigation funding works. But there are jurisdictions, and I have seen myself that litigation funding works. People have been taking it, especially let's say US. Yes, it does. I have seen an example where a person is saying that I have a good case made out. Unfortunately, I don't have money to go through the entire process because US litigation could be very expensive. Then this guy brings in a funder. Funder actually sees the case. Actually, case is very good, and funder funds, but then shares the profit, right? And in commercial disputes, it's very easy to fund litigation, and as I say, a lot of jurisdictions do it. In India, I think very difficult. I think whether it's good or bad, in my view, it gives a party an opportunity to at least try their luck. In my view, for some cases in India, it should pick up pace. Just to give an example, Ajay, you said for arbitration, for commercial arbitration disputes, I'm being very specific, right? It People should be able to do it. I think we should have an opportunity to do it. For others, I think our mindset is not so evolved as yet.
Just to add a number again, I saw one number that the global litigation funding market $43 billion by 2033, which is not far. And also the Indian market projected to grow at 10.6 CAGR. So these are very interesting numbers, and I hope there's no typo on the data which I got. I couldn't believe, but again, in India, since we don't have contingency fee allowed, so we can't really follow the US model where they know profit sharing or fee sharing works. Back to you, Kingshuk.
I just only want to say that litigation funding is very much prevalent outside of India. And in fact, what is interesting is I don't want to take names, but there is a investment treaty between two nations that I went through recently in the context of some work. And there was a specific clause that litigation funding is not permitted. So that's the importance states are giving to litigation funding. It's a reflection of the fact that this is actually happening. I think as far as litigations in UK, Singapore go, litigation funding is very much prevalent and it's certainly an option. But I agree with Natasha, Vivek, you that in India it is difficult. Enforcement is always a challenge, and that seems to be the biggest concern that funders have. That look, you may have a favorable award, but as Ajay said, if it's a paper award, then where is the money? So, but it's an option. I'm conscious of time, and maybe we can spend a few minutes just quickly talking about technology and AI. I know, Natasha, you mentioned, you alluded to use of technology to manage costs, but is there any other means that technology, AI can help in managing litigation? Uh, we can perhaps get some comments from all of you on that. Natasha, you want to go first?
Yeah, I'll take it up, King Shuk. In fact, I would like to use technology more and more as much as I can. And it is coming really fast at us, isn't it? We're no longer in the times of diaries, the black diaries we used to have and we put our dates, everything. That time is, I think, definitely gone. I wanted to talk about technology. It's still slow coming, and some of it we already use. But I think I'd divide it into three. One is litigation management. management systems. There are quite a few in the market where they have been for a very long time, which effectively keep all the litigations and the dates and what next in one place. I can take a few examples and names. There's Provokeel, there's Legistify, there is Jupitus. There are a plethora of other platforms which have come about as well. So I do think that they would have and would make litigation management a little more efficient and put together and in one place, and that's great. I do hope that they keep in mind the very strict data privacy laws that our country is impendingly getting into as soon as the notifications come for the regulation. So that those are technology developments which are already in place and are happening more and more and can really make litigation management a more efficient process than it used to be. I also like to point out to these various ODR systems and platforms that have come about. SEBI has made one mandatory already. These are, small value, maybe disputes, not so much value, which can be taken up on these ODR systems, which have everything. They have mediation available, they have arbitration available, and also very easy access. I think there's SAMA, there is Presolve, there is CODR. There are quite a few of those as well, and that's also very technology driven, making sure that the time value of money becomes more clearer to everybody, and everybody has access to justice as well. So I think those platforms are something will take some time to imbibe themselves, but I think they already have in certain industries. Very quick example of everyone, I think everyone would be aware of this, is this Uber apps as well, and your urban club, where if you have a dispute, you can just raise it on your phone and immediately it gets resolved. It keeps things very efficient and ongoing, and nobody has to waste their time. That was another one which was that I do want to talk about is we have been using these, right? We don't go through libraries and take out books and take out case laws anymore the way we used to, at least my olden times, but not any longer. We have good platforms available. Manavatra is catching up quite now. There's LexisNexis. There are more platforms where we can do our research and bring it closer. Taking that even a step further is now, which is coming very close to us at quite a speed, still not reliable, but coming to us at close speed, is AI, right? Even if you want to close your research much faster, you have to double check it, of course. If you're using, say, a chat GPT, it will give you information, of course, with the whole caveat that you check it yourself and get in consultation with your lawyers, and then you check them yourself. But these have made life a little more efficient when you are running short of time, which a lot of us are at a lot of points of time. Also, I believe what's coming closer to reality is AI be used on the platforms of litigation management systems as well, where they themselves will extract the orders from the courts, they already do, but also be able to interpret and show next steps to the litigant, so that the litigant doesn't have to wait for trying to understand an order on what really it means. So AI would be able to do that. I think that would be beneficial to everybody, in fact. Of course, keeping a check on things, on exactly whether it's right or wrong, but these systems, I believe, would make everybody's life much more easier, and we'd be able to put in most of our time where it really matters, taking those critical decisions, rather than regular everyday work. It's great to do that in the first or second year of when you just start practicing, so that you know the basics, so that you can counter check them and make sure that AI is not misguiding you, which it could. But these are a few of the new technologies coming our way, and I think it's really important, even if we don't use them, to keep trying them to make sure we can, get away from the loopholes that they provide as well, and caution ourselves as to how best we use them. I'm sure there are more platforms, but these are the ones that I know of, and I'm trying to keep myself abreast of.
Yeah. I am unfortunately running out of time. I had a host of other questions. AB, sorry, I don't have too much time left, but there's one last question which I'm going to take from one of the audience questions that's come our way, which is how important. I think in some ways you've answered this, Vivek and Natasha, but how important is it to detect a dispute early on for you to be able to manage the litigation later in a better sort of way? How important is that? And how do you do that? What are the approaches to be able to do that? Is there any advice or recommendation or suggestion on approach? Maybe you all can each
Yeah.
take 2 minutes.
Yeah. So I think answer is yes, very important, right? If you are able to detect the dispute earlier and you can resolve it. I the way I see it, this will apply only in cases where you have two parties, two commercial parties, right? And in relation to them, it's not in relation to probably government where you can't predict anything, right? Tomorrow there is a notification, today there is not. So in relation to commercial parties. Normally for any large agreements, what we do and what I would suggest always to anyone is that have a joint steering committee. Try and monitor that what the steering committee is doing, what kind of issues they are discussing, what are the disagreements between them, whether they are minuting everything or not, and pick up from those minutes if there are any early signs of dispute. That's one way to deal with the early signs of dispute, and then probably resolve it much faster versus being escalated to CEOs, then mediation and arbitration or litigation. So that's one way. But is it important for larger commercial issues? Yes, fully yes. We do a lot of joint development, we do a lot of joint ventures, we do a lot of distributions where you know uh, things are dependent upon volumes. Let's say we say that okay, we'll distribute your product, this is the license fee, but also we'll pay you volume based licensing fee, or profit sharing as well. In those cases it becomes very, very important. So answer is yes, and these are the ways you can pick it up.
Natasha,
And
briefly, if you have anything.
I'll add to that, and I'll say absolutely. Yes, I completely agree. It is very important to be able to pick up early signs of dispute. And for me, I think it works post facto for the litigation team. A litigation team and their data can really provide you with how the business is doing, the health of the business. If there are no litigations, then I would think maybe we're not doing business because it's inherent nature of business to have some litigation. But to be able to catch these early signs, I think the relationship we have with our business is so important, and we have to consistently from every dispute that we work on, big, small, large in number, large in quantum, it will have lessons learned. If those lessons learned while managing the dispute or after having completed the dispute, both times, if those lessons learned are consistently communicated to our business, we would often be able to pick up those red flags of an impending dispute. Something like that has already happened, or also the lessons learned could say, all of this is happening. Here are a few points to try and block those loopholes that have come about or mitigate a risk of a dispute that might be arising. And I think often, very often, the main red flag is communication breakdown, whether it is between business and us, business and client, opposing party, during a dispute, prior to a dispute, or even post a dispute. As soon as there seems to be any sign of communication breakdown, that's a red flag that we are heading towards an impending dispute.
Thank you so much. I think it was, and I think all of us will agree, it was a very, very thought-provoking discussion. We've actually, personally for me, a lot of learnings, a lot of takeaways, um, and I know we can go on and on, but time is always an issue. AB Ajay, do you have any final closing comments on what we've discussed? Any takeaways? Maybe you can spend a couple of minutes and then we'll go into the closing formalities. But I
Sure.
want
I
to
mean,
personally thank Natasha and Vivek for taking time out for this. Really, really appreciate it.
no, no.
AB.
My
Oh,
key takeaway
absolutely.
was on the cost management, what the expectation are, and I must say the role of in-house counsel has evolved so very much. From the time I started, there were hardly in-house lawyers in 96. The few who went in-house, we said, what happened? Practice is not working or what? Today, fast forward where we are, and I'm often asked on various platforms, what do you see the role of in-house and external? I say we are in the same game. Like in Hindi, there's a statement, "Ek hi thali ke chatte batte." So it's like the same team, and it's been fun. And since we are on this webinar, let me acknowledge my personal growth in the pharma space to Vivek. You will not believe he is the one who really got me into this space in 2013. And I mean, I'm just sharing a in-house and external counsel bonding. That time, the control order had just been released, went into some funny litigation, and Vivek and me connected. I don't even know how, but that's beyond. And I told him, he asked me, "What's your experience?" And I said, "Nil." He said, "Don't worry, I'm there." And that is, I mean, Vivek is here, so I can share that I will never forget in my life. And today, if somebody says you are I mean, I'm called as a drug lord by a few people in Delhi High Court because I do a lot of pharma matters. I owe that to Vivek. So that's the role of in-house counsel for me in my life.
Yeah, and if I can only add that, sometimes you as in-house counsel, you take positions, views which are unpopular, contrary to what maybe your management wants you to take, or sometimes even what we advise you as external counsel. But I do feel that in the interest of the organization, long-term interest of the organization, that is what your role is and your responsibility is. It's a really tough one, but I think the importance of in-house team cannot be gainsaid. So that's my thought. And again, thank you so much, all of you, for joining us for this webinar, taking time out. Even our audience, thank you so much for joining us. We have some closing formalities, which if you can please bear with me on. Before closing, may I request each of the audience members to please respond to the poll slide that you will see on your screen and provide your feedback on today's webinar. We take this very seriously as part of our continuous improvement program. Uh, Raja, if you can pull the poll slide up. Thank you all for participating. Lot of learning for me. Please separately send in your feedback. You will receive a request from us after the webinar. We will also be sending you the summary notes and a link of the webinar recording. Your feedback is very important for us, so please do send in your feedback. This happens to be the last in-house counsel forum webinar for 2024. I hope you enjoyed it, and thank you once again for joining us.
Thank you all. It was very interesting.
Thank you.
Thank
Thank you
you.
all.
Thank you.
Thank you,
Bye-bye.
Vivek. Thank you,
Bye.
Thank you, Ajay.